Welcome back to another Explainer. Today, we're taking a deep dive into a truly landmark constitutional court case that gets right to the core of what a fair justice system actually looks like in the real world. We're going to explore that incredibly delicate balance between enforcing the law and protecting human rights. This is a story about crazy delays, clever legal maneuvers, and a fundamental constitutional right that literally affects tens of thousands of people every single day. We're looking at the 1998 South African Constitutional Court judgment of Wild v. Hoffert, penned by the legendary Justice Kriegler.
Okay, let's dive into this. Picture this. You're arrested and slapped with a really serious charge. But instead of facing a judge and getting your day in court right away, you wait, and you wait. You sit through postponements, procedural hiccups, and a mountain of institutional red tape. Months suddenly turn into years. So if the state takes 5 long years just to finally bring you to trial, should your charges be dropped entirely? Does the sheer passage of time invalidate the whole prosecution? Well, that is the high-stakes mystery right at the heart of our legal conflict today.
Section 1. The Incident and Timeline. Let's look at this 1993 cocaine bust.
So this whole thing kicks off on a Saturday evening, June 19, 1993, down in Durban. An attorney is hanging out at an advocate's house. Shortly after, a couriered envelope is delivered, which allegedly contained cocaine. Next thing you know, members of the South African Narcotics Bureau, SANOB, raid the house. It's total chaos, and a policeman actually sustains a gunshot wound during the raid. The 2 legal professionals are arrested right on the spot, facing charges for dealing in or possessing cocaine, plus an additional heavy charge of attempted murder. As you can probably guess, 2 prominent legal figures getting busted in a wild drug raid sparked massive media attention. National radio news, Sunday papers, the story spread like wildfire, causing both of the accused immediate and severe social and professional embarrassment.
But what happened next was definitely not a swift trial. It turned into this absurd 5-year timeline of legal ping-pong. Let's walk through it. After the arrest in June 93, the case saw a bunch of remands for quote-unquote further investigation. They finally set a trial date by consent for May 1994. But here's the twist. By May 94, South Africa's interim constitution had come into effect, bringing a whole new set of rights for accused persons. The defense, being savvy lawyers, decided to use these new rights. They launched an application to the High Court challenging police docket access and the constitutionality of certain presumptions in the drug laws. Because of this constitutional detour, the main criminal trial was just paused. But then the High Court application dragged on forever. The state completely dragged its feet, failing to file affidavits for months. Frustrated by the absolute lack of progress, the trial magistrate threw their hands up and struck the criminal case from the roll in March 1995. The accused thought it was over, but nope. In November 1995, the state re-indicted them, summoning them back to court on essentially the exact same drug trafficking charges. This endless back and forth establishes our massive knowledge gap. Does a delay like this mean they just get to walk free?
Seriously, does a long, drawn-out delay fundamentally mean you get a free pass? This guiding question completely pivots our narrative away from the gritty facts of a Durban drug bust and squarely into the realm of constitutional legal analysis.
Section 2. The Speedy Trial Right, and what the Constitution guarantees.
Section 25, subsection 3A of the Interim Constitution guarantees every accused person the right to a fair trial, and that explicitly includes the right to a public trial before an ordinary court of law within a reasonable time after having been charged. The Interim Constitution ranks this right to a speedy trial at the absolute forefront of a fair criminal justice system. Justice Kriegler noted that on the face of it, the language is crystal clear. The touchstone here is reasonableness. The state has a constitutional obligation to make sure accused persons are not just left in limbo, exposed to unreasonable delay.
Section 3. Types of prejudice. And this brilliantly illustrates exactly how courts measure harm.
Now, what's really fascinating here is how the court clearly decouples 2 very different types of harm. On one side, you have trial-related prejudice. This is when the delay physically compromises the fairness of the trial itself. Think dead witnesses, memories fading over time, or crucial physical evidence getting lost in an evidence locker somewhere. On the other side, you have personal prejudice. This is the social and personal damage of a delay. We're talking about pretrial detention, meaning a loss of liberty, your reputation getting destroyed, social ostracism, or financial ruin. In the case of our 2 lawyers, they absolutely suffered massive personal and professional harm. Their reputations took a brutal hit in the press. But, and this is a massive but, their actual ability to defend themselves in court, their trial-related prejudice, was not compromised at all. They were out on bail, living their lives, and aggressively mounting a very complex defense.
Moving on to Section 4, seeking a drastic remedy and the demand for a permanent stay.
What the appellants were asking for was a permanent stay of prosecution. Let me be clear, this is an incredibly drastic legal remedy. If a judge grants this, the state is permanently barred from ever trying the accused for those pending charges. The case is effectively dead, and the accused walks away. Because it is so extreme, courts are incredibly hesitant to use it. Justice Kriegler explained that taking a sledgehammer to a case and throwing it out entirely is rarely the appropriate fix, especially when there's no actual trial-related prejudice.
So, the crucial point is understanding the intellectual hurdle here. Proving a delay is unreasonable does not automatically grant you a stay of prosecution. The court noted that we really can't conflate the infringement of a right with the remedy for that infringement. Step 1 is simply asking, was the speedy trial right violated? If yes, then you move to Step 2, which is asking, what is the appropriate remedy? Because the Constitution allows for flexibility, a court can tailor a really snug fit between the specific harm and the specific remedy. You don't need a sledgehammer if a scalpel will do the job perfectly well.
Section 5. The final verdict from the Constitutional Court.
Ultimately, the appeal was dismissed. The court held that because the appellants lacked trial-related prejudice, meaning their ability to actually defend themselves wasn't hindered by the lost time, and because there were no other highly extraordinary circumstances, their request to drop the charges was completely denied. The state was allowed to proceed with the prosecution. The court reasoned that even if the state was partially to blame for that crazy delay between March and November 1995, without trial-related prejudice, a permanent stay of prosecution was just simply the wrong remedy.
But Justice Kriegler didn't just end his judgment there. He brilliantly bridged this specific case to the massive systemic impact happening across the entire country. He highlighted that there are tens of thousands of awaiting trial prisoners currently sitting in correctional facilities. To put that into perspective, that's enough people to fill a sports stadium, just sitting there in limbo. Multiple postponements are this endemic blemish in the magistrates' courts, with some courts dedicated to nothing but remanding endless streams of cases day in and day out. The financial cost to the country is staggering, and the cost in social disruption and human misery is frankly incalculable.
To combat this absolute mess, the Constitutional Court outlined some very actionable instructions for prosecutors and magistrates to actively prevent these systemic, endless remands. Magistrates aren't powerless in their courtrooms. They must demand explanations under oath from investigating officers who are asking for delays. They can adjust or lighten bail conditions to relieve personal prejudice on the accused. They can and absolutely should refuse unreasonable postponements, which might actually force the prosecution to withdraw the charges entirely. Furthermore, they were instructed to utilize the newly introduced Section 342A of the Criminal Procedure Act, which gives courts the real power to investigate unreasonable delays and even slap the state with costs.
Which brings us to the profound conclusion of this explainer. Justice Kriegler wrote something so powerful. He said, "Punishing the guilty is important, but it is at least equally important that it be done in a manner worthy of that new order." I think that perfectly summarizes the delicate, vital balance between enforcing the law and upholding fundamental constitutional rights. It forces us all to ask ourselves a pretty tough question. If a justice system breaks the law in order to enforce the law, can we really call it justice? Thanks so much for joining me to unpack this fascinating material today, and I really hope it leaves you looking at our court systems in a completely new light. See you next time.